Hello. Hello. Happy was it Monday today? Made it through the weekend. Great. now now we get to go through Mondays. Many of you already know Monday is my least favorite day of the week. so not very happy about that, but whatever. We'll do what we can, right? Goodness. Alrighty. There we go. That's all right, I think. Yeah, we're okay. Is that okay? Let's see. One more lookaloo here. Welcome. Come on in. I'm just grabbing my rings for today. There we go. Got it. All right. Yay. Got it. All right. Get myself sorted out here. We're going to do a little lunch and learn today. So we've got some really big news that just broke, so I'm very excited. It could have broken a few days ago, but I'm gonna just say, hey, look what happened, because that's kind of cool. So here we go. Am I good? I'm not sure if I'm good. Just one second. We have two dismissals. We have Letitia James' case against her has been dismissed, and the case against Comey, has also been dismissed. Hi, Liz. Welcome. Hi, Kelly. Welcome to class. So, yes. Oh, Sin. Well, here I am. I know, right? We can't wait on this. This is breaking news, right? Oh, goodness gracious. All right, everybody. Well, welcome in. I have two orders. And I thought they'd be the same because they're kind of going through the same process, but they are not the same. We've got one for Miss Letitia James, the AG of New York, and then one for Mr. James Comey. I'm not sure what his current occupation is, but former FBI leader person, director, or whatever. Yes. Oh, yeah, Kelly. I know. We've got to go through this. We've been watching this for a little bit. I know a lot of what you know. Excellent. Once again for the, oh yeah, absolutely. The courts are doing some good things here, right? It's just a matter of keeping it going through the process. Yes, indeed. It's time. Good news. We've needed that, big grandma, for sure. Well, welcome, Katrina. I'm glad you're here. We're doing a little lunch and learn today. More space on the closet docket. Well, you're not wrong. You're not wrong. Oh, taking a break to come. Right, this could be CLE credits. I mean, I don't have any to offer you, but it could be. Ooh, maybe I should try to do that sometime. My state would be like, what days are you doing? What's this TikTok that you speak of? Oh my goodness. Hello. Because dogs, of course. Yes, we all feel that way. For sure. Hello, everyone. The CLE credits, I know, wouldn't that be great? Right? Well, and I think her Pam Bondi is on the list. I have no doubt, there are a lot of people who are coming for that one. She can't be that awful in the highest position in the land for an attorney. Hi, James. Hello. Welcome. Good afternoon to you, too. Yes, exactly. That's what I'm saying, Max. You know, the list is growing. True. Bondi's not going to come out of this unscathed for sure. And the press lady person, she's also going to get dinged, I think, pretty significantly. But my guess, in all honesty, is that Patel will be the one who gets kicked out of the cabinet first. That's my guess. We could make some guesses, but that would be my guess, is he's going to be the first one out of the cabinet. Yeah, Triple K Caroline. Sparkles. Oh my gosh. Yeah, she's a little different You think Rubio? It could be. It could be Rubio. Two orders to dismiss, Dominic. I'm going to go ahead and start getting right through them because I just printed them as soon as I saw that they had been made public. So I've not annotated them. We don't need these annotated, hopefully. But here's what we've got. Spork, yeah, I think he has actually, okay, two things. I think he used like the FBI jet or something for his girlfriend, right? For transportation. And then word on the street is he had been requiring or requesting FBI SWAT to protect her. So 2 times he has used the FBI tools for personal use. Right, so there's that. Good day to you, Mr. Mayo. I think once one goes, we're gonna see several of them. Yeah, major. I know, right? With the plane, I was like, man, you could do a little dance and get around that because whatever. But when I saw that SWAT teams were being used, they got other stuff to do. So there you go. Yes, hello, Suzanne. So I think that's why he's on my radar as one of the first ones to go, I would say. All right, everybody, we're going to lighten the mood a little bit. We're going to use a pink pen here today. So what we have is our judge out in Virginia here was in charge of both cases, Letitia as well as Comey. Now, I've taken you through both those indictments at different times. We have Combs, we all heard about the grand jury snafu, but 2 counts against him for, stuff he said to Congress. And then we have Miss James, AG in New York. And there were some questions about a piece of property that she, purchased. And they're trying to be like, what? Will they refile the charges? Unknown at this point. But I tell you, that's my new phrase now. I tell you, what I would say though is they've got so many other things going on. I'm not sure they would want to push this one through again with both of these. But I as we go through this, we'll have to see the rationale of the judge. And then, we'll have to say, do you think this is going to help them make a good choice on whether or not to refile or not? And again, only if it's is dismissed without prejudice, which we do not know if that is how it is written. All right, hold on, everybody. Oh my gosh. So, yeah, I think when you're this picky about your pens, it can take a minute for you to find the right pen. All right, here we go. So we have, we have dismissals is what we're looking at. Dismiss. And we have one for Comey here. And then we'll also take a look at Miss James, of course. So James here. And then let me get the 2 names, the 2 case numbers here. So we've got 125CR00272. And then we have 225CR00122. I like to narrate as I write. So those are the cases, and these just came down. So this is hot off the presses. I don't know, do we have presses anymore? Does anyone know that? The answer to that. Does anyone know if we have presses? Oh my gosh, the court martial of Mark Kelly. Oh my goodness. I tell you what, Dr. House, because I'm saying that apparently to everyone all the time. When I read that headline, I thought to myself, oh dear, I don't think I have enough popcorn. Yes, we're gonna have to kind of wait and see how that one's gonna go forward. It's gonna be a mess. It's gonna be a mess. She needs to buy a turkey, Aaron, it's so funny. It's funny because it's true. Oh my goodness. So here we are, everyone. This is Miss Letitia James's, and this one here again is Comey. So I want to grab the Comey case first because I think it's the most complicated because we have those grand jury issues going on. So we'll go ahead and get her started with this one. How do you court-martial a retired officer? Well, you charge them with a military law violation, and, you can pull them in through there. They're still going to jail. Who's going to jail? Bits and pieces. It's scathing. I know, right? I think, you see the headlines. Like, what's happening? I know, it's a lot. Hello, Kristen. Oh, no, we're there. We got it. Can they sue for wrongful prosecution? They certainly could. And it seems like those are the grounds that the cases were dismissed out of. So we definitely have a criminal case here that the judge is kicking out, but then there's the civil road. Both of them could go down if they wanted to. So here we go. Let's dive in. Oh, this needs to be over here, and I need to have my hot cocoa. And I need to make sure no cattails under my chair. All right, here we go. Opinion and order granting motion to dismiss indictment for the filing of 60. And that's, again, corresponding with Comey. Miss Letitia James's is number 22. Okay. On September 25th of 2025, Lindsay Halligan, a former White House aide with no prior prosecutorial experience, appeared before a federal grand jury in the Eastern District of Virginia. Having been appointed interim U.S. attorney by the Attorney General just days before, Ms. Halligan secured a 2-count indictment charging former FBI Director James Comey with making false statements to Congress and obstructing a congressional proceeding. Right. All right, Mr. Comey now moves to dismiss the indictment on the ground that Ms. Halligan, the sole prosecutor who presented the case to the grand jury, was unlawfully appointed in violation of 28 U.S. Code Section 546 and the Constitution's Appointments Clause. As explained below, by the way, quick side note, this is exactly the law that they used to pull Jack Smith off of the case in Florida. All right, even though his appointment was different, but these are the same laws. As explained below, I agree with Mr. Comey that the Attorney General's attempt to install Ms. Halligan as interim U.S. Attorney for the Eastern District of Virginia was invalid. And because Ms. Halligan had no lawful authority to present the indictment, I will grant Mr. Comey's motion to dismiss the indictment without prejudice. So that's our first piece. Without prejudice, which means technically they could come back and refile, technically. But does anyone see a problem? Does anyone know what the true problem is by trying to bring this case again? Anyone? Bueller? Right. For wasting statute of limitations. You got it, S'mores. That's right. So the reason she ran into this, we're a learning channel here. We are a sarcastic learning channel. Debates are like in the other creators' worlds. So, right, we've got the statute of limitations, everybody. Now, every crime has some kind of a statute of limitations when the time runs out. And if you don't file or charge someone by that date, your case is what we literally call in the legal field, we call it toast. So don't forget that legal term. Except for homicide. Homicide has no statute of limitations. But yeah, she hurried and rushed us through so that they could toll the statute of limitations. Now the statute's gone, right? It's already passed. And so if they were to try to bring this case again, they're going to run up against that statute of limitations. Should it not say allegedly? That's a good question. I'm not sure. I feel like the judges just get warmed up here. It's like, wait for it. Here we go. Legal background. The Appointments Clause And oh, by the way, too, I had set this really, really cute, incredibly adorable little creature to be the live goal things. So if I'm going to try to look over and catch it because I haven't seen its full animation, because sometimes, you just want that. You want to see something cute. Anyway, that's at the top, so I'm going to keep my eyes peeled for it. Here's our legal background. The Appointments Clause prescribes the exclusive means of appointing officers of the United States. The text of the clause contemplates two types of officers, principal and inferior officers. The potato, that's right, the French potato. Oh my gosh, it's holding little baguettes. I can't even believe it. I can't stand it. Look at the baguettes. Thank you so much. Appreciate that. Oh, we love that. We love that. I mean, right. Anyway, I'm sorry. That one I just was laughing out loud, and I'm like, that's the one. Anyway, here we go. Principal officers must be appointed by the president with the advice and consent of the Senate. Citing Constitution, Article 2, Section 3, Clause 2. Section 2, Clause 2. The same process is also the default manner of appointment for inferior officers. Cited here. But the framers recognized that requiring all officers of the federal government to run the gambit of presidential nomination and Senate confirmation would prove administratively unworkable. Although, honestly, Madison probably could have figured out a way. But, to each their own. So, on one of the last days of the Constitution Convention, they authorized an additional and streamlined method of appointment for inferior officers in the final provision of the Appointments Clause. That provision, sometimes referred to as the Accepting Clause, here, quoting the Edmund case, permits Congress to, by law, vest the appointment of inferior officers in the president's alone, in the courts of law, or in the heads of departments. Quote, for United States attorneys, Congress has preserved the constitutional default rule of presidential appointment and Senate confirmation. And then we've got our string cites here. Okay, here we go with the footnote setting out the U.S. attorneys there as well. Yes. Yes, and I, without a doubt, will say words incorrectly. So that's just going to be part of the experience here. Oh my goodness, here we go. All right, so the president shall appoint by and with the advice and consent of the Senate a U.S. attorney for each judicial district. Congress has also established a mechanism set forth in 28 U.S. Code, Section 546, for appointing interim U.S. attorneys when a vacancy arises. Section 546 essentially, quote, divides the responsibility for making interim appointments between the Attorney General and the district courts, citing the Baldwin case, and it provides in full, here's the rule, except as provided in subsection B, which is this, the Attorney General may appoint a United States attorney for the district in which the office of the United States Attorney is vacant. Here's B, the Attorney General shall not appoint as United States Attorney a person to whose appointment by the President to that office the Senate refused to give advice and consent. And then C, a person appointed as United States Attorney under this section may serve until the earlier of 1, qualifications of a United States Attorney for such district appointed by the President under Section 541 of this title, or 2, the expiration of 120 days after the appointment by the Attorney General under this section. So, of course, we have to remember Ms. Haba in New Jersey was having this kind of a trouble as well. So this has been going on in a lot of places. D, if an appointment expires under subsection C2, so C2 here, all right, the district court for such district may appoint a United States attorney to serve until a vacancy is filled. The order of appointment by the court shall be filed with the clerk of the court. Hello, Mo. Hello. Yes, Ms. Haba out there, right? All right. She got set up, I think. And she may have set herself up to walk down the road she didn't know anything about. Hello, Reed. Welcome. Welcome. Nunya as well. So here we go. Factual background. Let's make sure I've got the right page order here, because my cats have been playing with my stuff lately. There we go. All right. On January 20th, Jessica Aber, who had been nominated by President Biden and confirmed by the Senate, resigned from her position as U.S. Attorney for the Eastern District of Virginia. The following day, the Attorney General appointed Eric Seibert as interim U.S. Attorney under 28 U.S. Code 546. Mr. Seibert's 120-day interim appointment was set to expire on May 21st. So on May 9th, the judges of the district exercised their authority under Section 546 sub D to appoint Mr. Seibert to continue in his role effective May 21st. So the courts wanted him to stay, right? They wanted the person that was in there to stay. Who cares what the parties were? It's the courts. The courts said this person can do the job. On September 19th, Mr. Seibert informed colleagues of his resignation. According to news reports, because that's included in everything now, including district court orders, because that's what we do now, had recently expressed concerns to senior Department of Justice officials about the viability of pursuing charges against Mr. Comey and New York Attorney General Letitia James. Mr. Seibert's resignation came hours after President Trump, I gotta change that word, Orange, told reporters at the White House he wanted Mr. Seibert out, because that's professional. The next day, President Orange posted and later deleted the following message on social media. Here we go. This is the message that kind of started all of this here. Right, so let me just make sure I've got, there we go. Pam, I've reviewed over 30 statements and posts saying that essentially same old story as last time. All talk, no action. Nothing's being done. What about Comey, Adam Shifty Schiff, Letitia? They're all guilty as HE double hockey stick, but nothing's going to be done. Then we almost put in a Democrat supporting U.S. Attorney in Virginia with a really bad Republican past. A woke rhino who was never going to do his job. That's why two of the worst Dem senators, this is a direct quote from a social media account, TikTok, all right? Just letting you know, I'm not putting this forward as truth. Dem senators pushed him so hard. He even lied to the media and said he quit and that we had no case. No, I fired him, and there is a great case, and many lawyers and legal pundits say so. I'm not sure that they do. Lindsay Halligan is a really good lawyer. Now we know that's not true. And likes you a lot, to Miss Pam Bondi. So I don't know how that's going down. We can't delay any longer. It's unaliving our reputation and credibility. They impeached me twice and indicted me 5 times. Over nothing. Justice must be served now. In all caps, President DJT. Every time I read it, it's funny. Oh, my goodness. Less than 48 hours after President Orange's post on September 22nd, the Attorney General issued an order authorizing Lindsay Halligan to be the interim U.S. Attorney for the Eastern District of Virginia during the vacancy in that office. So that's set out here. September 22nd order cites only 28 U.S. Code Section 546 as the basis for Ms. Halligan's appointment. Okay, hello Mimi, welcome. On September 25th, a grand jury, that's the hubs trying to sneak out of the house as quietly as possible. Have a good one. He's like picking up his shoes and his bag and like walking out the door. He's trying to not make too much noise. Oh, that was so adorable. All right, back to it. Sorry about that. All right, I just turned the page. Oh, hi, Kaya. Hello. Right. On September 25th, a grand jury sitting in the Eastern District of Virginia returned a 2-count indictment against Mr. Comey, charging him with making false statements within the jurisdiction of the legislative branch in violation of 18 U.S. Code Section 1001 sub A sub 2. Here, that's the thing, Jenny. That's the thing that's getting all of us out here as attorneys. It's like, well, we're telling you how this is. And so if someone's telling you something different, that you're going to have to really take a look at that person and see where they're at in their world. And obstructing a congressional proceeding in violation of 18 U.S. Code Section 1505. The charges stem from testimony Mr. Comey gave during a Senate Judiciary Committee hearing in 2020. Ms. Halligan was the only prosecutor who participated in the government's presentation to the grand jury, and only her signature appears on Mr. Comey's indictment. All right, it's all her then. Procedural history, October 20th, Mr. Comey moved to dismiss the indictment on the grounds that Ms. Halligan's appointment was unlawful under Section 546 and violated the Appointments Clause. On October 21st, the Chief Judge of the Fourth Circuit designated me, the judge, to consider this and any other motion concerning the appointment, qualification, or disqualification of the United States Attorney or the United States Attorney's Office in the Eastern District of Virginia. So, oh my gosh, did I miss one of the taters? Oh, it's so adorable. I just can't even help it, everybody. It's just so adorable. Let's bump down here and read this footnote. The footnote was set out. Oh, thank you. Oh, it's so fun to see all these little treats when they come up on the screen. So footnote number 10 is back. Where did it go? I just had it. Where did it go? Nope. Well, that's 11. So, we went too fast. Here it is. It's up at the top. So footnote 10 down here, all right? The grand jury was originally presented. So this is the definitive piece now of what happened with the grand jury, okay? The grand jury was originally presented with a 3-count indictment. At some point, however, a second 2-count indictment was prepared. It is unclear by whom, which removed count 1 of the original indictment. And all of this is on the record, too. Both indictments were signed by Ms. Halligan and the grand jury foreperson and were returned to the magistrate judge. During the indictment return proceeding, the foreperson explained that the grand jury did not agree on the very first count, and that counts 2 and 3 were then put in a different package, which we agreed on. After speaking with Ms. Halligan, the magistrate judge accepted the return of the second 2-count indictment and instructed the foreperson to annotate the, quote, report of a grand juror's failure to concur in the indictment to reflect that it applied only to count 1. So this really got tangled up. This got tangled up quite a bit. And it seems like one of the easiest things got tangled up here, right? You put the indictment there, they look at it, they agree, they don't agree, you're done. Like, I mean, you don't tidy up a grand jury indictment. You deal with the mess you made and then clean it later. That's how it goes. All right, finding a Sorry. Sorry about that. Sneezies today. Hello, Sue. So, finding it necessary to determine the extent of Ms. Halligan's involvement in the grand jury proceedings, I ordered the government on October 28th to, thank you so much for the blessings. Aw, you're so sweet. All right. Halligan's involvement in the grand jury proceedings. I ordered the government on October 28th to submit for in-camera review in chambers all documents relating to Ms. Halligan's participation before the grand jury, along with complete grand jury transcripts. Upon reviewing the transcript provided by the government, I determined it did not include any remarks made by Ms. Halligan, quote, before and after the testimony of the sole witness. We have one witness. So that's not good. Accordingly, on November 4th, I directed the government to submit a complete transcript and/or recording of all statements made by Ms. Halligan to the grand jury on September 25th. In a notice of compliance filed on November 5th, the government represented it had produced all materials requested by the October 28th and November 4th orders. So the government said, well, we gave you everything we have, right? So in response to the October 28th order, the government provided that the transcript of the grand jury proceedings that was previously provided to the government by the transcription service. The court's subsequent November 4th order additionally requested the recording from the grand jury presentation. Upon receiving this order, the government immediately contacted the transcription service and requested the complete recording. Further, the government requested that the transcription service transcribe the entire recording, which had not been done previously. This new transcript was provided to the government on November 5th. Then, above items have now been provided to the court in compliance with the court's orders. So it was sorted out later, but it took a little bit of time. So next up, on November 3rd, the government responded in opposition to Mr. Comey's motion. Also that day, the government filed an order from the Attorney General dated October 31st. Here, the October 31st order reads in its entirety. So here we go, entirety. Flipping. Oh dear, here it is. It certainly is in its entirety. Here we go. On September 22nd, here, let me bump this down a little bit. I don't want to lose the blue background for the comments, but I think we'll be okay here. On September 22nd, I exercised the authority vested in the Attorney General by 28 U.S. Code, Section 546, to designate and appoint Lindsay Halligan as the United States Attorney for the Eastern District of Virginia. Here, for the avoidance of doubt as to the validity of that appointment, and by virtue of the authority vested in the Attorney General by law, including 28 U.S. Code Section 509, 510, and 515, I hereby appoint Ms. Halligan to the additional position of Special Attorney as of September 22nd, and thereby ratify her employment as an attorney of the Department of Justice from the date going forward. As Special Attorney, Ms. Halligan has authority to conduct in the Eastern District of Virginia any kind of legal proceedings, civil or criminal, including grand jury proceedings and proceedings before United States magistrates and judges. In the alternative, should a court conclude Ms. Halligan's authority as Special Attorney is limited to particular matters, I hereby delegate to Ms. Halligan authority as Special Attorney to conduct and supervise the prosecution in U.S. v. Comey and U.S. v. James. Yikes. In addition, based on my review of the grand jury proceedings in United States v. Comey and U.S. v. James, I hereby exercise the authority vested in the Attorney General by law, including 28 U.S. Code Section 509, 510, 518 sub B, to ratify Ms. Halligan's actions before the grand jury and her signature on the indictments returned by the grand jury in each case. So, wow. So this is Pam Bondi coming in with her kind of like, genie complex, where she's saying, I'm so special. If this person did anything wrong, I'm going to say it wasn't wrong. And if you want more information, I'm going to say we're not giving it to you because I don't have to, because I'm special. So I think we've definitely got some issues with Miss Bondi. I think she's feeling like she's more important, more special than others. And I'm not sure how long that's going to hold out. Yeah, she is a lot. Oh my gosh, yes. So Mr. Comey filed his reply on November 10th. On November 13th, I heard oral argument from the parties and took the matter under advisement. During the hearing, I raised concerns about the Attorney General's ability to review Ms. Halligan's presentation to the grand jury, when, as of October 31st, the government had not yet received the complete transcript of the proceedings. See, he's like, that's hinky. I also noted that based on my in-camera review, there appeared to be a gap in the grand jury transcript between 4:28 p.m. and to 6:47 p.m. That's a decent amount of time here when the indictment was returned to the magistrate judge. I mean, this is a huge block of time. I'm not talking 15 minutes. Hinky, that's right, Steffi. Hinky business going on here. So we'll switch over here, page 9. The day after the hearing on November 14th, the government filed an unsworn declaration from Ms. Halligan and a new ratification order from the Attorney General. This is a lot. I mean, this to be having to file declarations with the court to clarify your own bad behavior, like that's not a good sign. That's not a good sign for you. Right. So new ratification order from the AG. So the AG is trying to clean up her mess a little bit here. Halligan declared that, quote, that the grand jury transcript accurately reflects the full extent of her appearance before the grand jury. Pausing, how are we supposed to believe her? Right? How are we supposed to believe Miss Halligan? She's saying, trust me, bro. And what has she done to show her credibility to the judge, to the courts, right? Not much. And explained that the period in question consisted solely of the grand jury's private deliberations. She further stated that there was no additional presentation, interaction, or discussion with the grand jury outside of what is reflected in the transcript. Here, for her part, the Attorney General stated she has reviewed the entirety of the record, now available to the government, and again ratified Ms. Halligan's actions before the grand jury and her signature on the indictment returned. So now the judge doesn't know if he can believe what Bondi's doing either. So the credibility, the very first time credibility got brought up was in the JGG case, or the planes heading to El Salvador that were directed to turn around. That's when credibility really came out. But now we're seeing it case after case after case. Our judges are not feeling confident in what the government lawyers are saying. And that sucks, because a lot of how things get done is to, you have this level of professionalism that takes you through the whole process. But if your judges are losing respect for you, that's going to be a tough road. That can only be cured with hot cocoa. No, I'm just kidding. All right, here we go. Here we go. Yikes. The discussion. Resolving Mr. Comey's motion requires me first to decide whether Ms. Halligan was validly appointed as interim U.S. Attorney under Sections 546 and the Appointments Clause. If the answer to that question is yes, I need not go any further, and Mr. Comey's motion must be denied. But if the answer is no, and Ms. Halligan had no authority to present Mr. Comey's indictment to the grand jury, then the question becomes what remedy is appropriate. Should the indictment be dismissed? And if so, should the dismissal be with or without prejudice? I address these issues in turn, beginning with whether Ms. Halligan's appointment was valid under Section 546. All right, Ms. Halligan's appointment, subsection A. And the judge here is saying Ms. Halligan's appointment violated Section 546. According to the government, this case is, quote, simple. In its view, the one and only limitation on the Attorney General's authority to appoint interim U.S. attorneys under Section 546 is subsection B, which bars the Attorney General from appointing anyone whom the Senate has refused to confirm. So only if the Senate said no. Nothing in the text, it continues, explicitly or implicitly precludes the Attorney General from making multiple interim appointments during a vacancy. Thus, it concludes, because the Senate has not refused advice and consent to Ms. Halligan, the Attorney General lawfully appointed her as interim U.S. Attorney. So this is weird, right? This is really a weird thing. They're saying the Senate has not refused any advice and consent about this person that we probably haven't even told them about, right? So then the Attorney General lawfully appointed her because nobody said anything out of the Senate. That's, again, Ms. Hannigan. Yeah. So anyway, the point was like that muddied things up too. Mr. Comey counters that section 546 limits the total tenure of the Attorney General's interim appointments to 120 days, and therefore precludes an additional appointment by the Attorney General after the expiration of the 120-day period. Accordingly, he argues, Ms. Halligan's appointment was unlawful because the district court possessed the exclusive authority to appoint an interim U.S. attorney once Mr. Seibert's appointment by the Attorney General expired on May 21st. Mr. Comey has the better reading of the statute. So his perspective, how he presented it, was you've got 120 days. After that, it goes to the courts to decide who they want to have there. And you have to set that out properly because the courts wanted Mr. Seibert there. So that's important. Both cases dismiss, yes. And I'm going through the Comey case right now. So when they put these little lines in here like that, I think is always interesting. Like, it has the better reading of the statute. So it's not like someone's right or wrong. It's just that he read it better. Like, all right. The preeminent canon of statutory interpretation requires courts to presume that the legislature says in a statute what it means and means in a statute what it says, citing case law. Thus, my inquiry begins with the statutory text and ends there as well if the text is unambiguous. The plainness or ambiguity of statutory language is determined by reference to the language itself, the specific context in which the language is used, and the broader context of the statute as a whole. Right, so, okay. Section 546 is unambiguous. Subsection A begins with authorizing the Attorney General to appoint a U.S. attorney for the district in which the office of U.S. attorney is vacant. Subsection C2, however, imposes a time limit on appointments made by the Attorney General. It specifies that a person appointed as U.S. attorney under the statute may serve until the expiration of the 120 days. This is what got Haba triggered or all tangled up when she was over there in Jersey. It's like, dude, 120 days, they're over. After appointment by the Attorney General, subsection D then provides a single option for how subsequent interim appointments may be made. If an appointment expires under subsection C2, the district court for such district and only the district court may appoint a U.S. attorney to serve until the vacancy is filled. So you get one shot as the AG. This is the person I want there. 120 days pass, now it's up to the court. So it's now the court's job to pick their who they want to have as the interim until the permanent position is filled, semi-permanent. The text and structure of subsection D in particular make clear the appointment power, 1, shifts to the district court after the 120-day period, right? And then 2, does not revert to the Attorney General if the court-appointed U.S. attorney leaves office before a Senate-confirmed U.S. attorney is installed. So that's clever. I think he did a good job on that one. So what they're saying here is within those 120 days, right, 120 days, that's up to the AG. But then it's over to the court. And then what they were saying was, well, the one you wanted wasn't there anymore. And so the court's like, just because he wasn't there anymore doesn't mean that you now, AG, get to appoint another one. You only get one. You only get one for 120 days. Anything after that, you need to talk to the court. The first word in subsection D, quote, if, end quote, introduces a conditional clause that establishes the condition triggering the district court's authority. And we're citing the Chicago Manual here. A conditional clause is an adverbial clause. That doesn't seem right at all. Adverbial clause typically introduced by if or unless establishing the condition in a conditional sentence. Usually, this is a direct condition indicating that the main clause is dependent on the condition being fulfilled, end quote. And I would explain it, but I don't know. Seems like just a bunch of excess words. That and getting in trouble, everybody. Sorry. Okay, bring it down. Tiger goes back in the cage. All right. The condition is met once an appointment expires under subsection C2. Emphasis added here. The indefinite article an points to a specific object, thing, or person that is not distinguished from other members of a class. And then we're citing a book. Probably like a treatise or something. So the expiration of any single attorney general appointment satisfies the condition. Thus, if, as here, the court-appointed U.S. attorney resigns, the district court, sorry, I lost my spot, retains the authority to make another interim appointment, because the triggering event, which is the expiration of the 120 days, has occurred. All right. So, and that's really important, I think, for everyone to note. She does not get to come back in and pick again. She picks the first time, she's got 120 days to find a suitable full-time replacement. And if she doesn't, it goes to the courts. And it stays in the courts, no matter how many times it needs to be discussed. Right. So, there's that. An appointment under subsection C2 has already occurred. Finally, the conjunction until, oh my gosh, all of these English. What? High school English, ouch. Finally, the conjunction until in subsection D's main clause defines the duration of the district court's authority. It lasts from the moment the condition is first met up to the time that the vacancy is filled by a Senate-confirmed appointee. Right, which is, again, there is. And next, this reading is reinforced by the negative implication canon, which recognizes that the expression of one thing implies the exclusion of others, citing Scalia, of course. I think there's somebody who was saying Judge Alito is also known as a judge. Alito as Judge Scalito, because you're so much like Antonin. Took me a minute. So Scalito. Anyway, I digress. Anyway, that's funny stuff. Here we go. To be sure, the Supreme Court has cautioned that a force of any negative implication depends on the context. Citation here, and that the canon applies only when circumstances support a sensible inference that the term left out must have been meant to be excluded. Here, however, the inference is not just sensible, but overwhelming. Congress assigned the authority to appoint interim U.S. attorneys to different actors in different parts of the same statute. First, to the Attorney General in subsection A, and then the District Court in subsection D. The omission of the Attorney General in subsection D, when combined with her inclusion in subsection A, is strong evidence Congress did not intend for the Attorney General to retain appointment power beyond the 120 days. Now, this is we're getting into the weeds. Why? Because whenever anything gets a final order to it, we look and see, is it going to be appealed, right? So even though we're in a criminal case, but this kind of a question, I think the judge is trying to set it out very carefully. And then we've got further case law here. Adopting the government's contrary reading would render subsection D insignificant, leaving it to lie dormant in all but the most unlikely situations. It's a bit dramatic, I think. So we're going to skip forward a little bit because this judge is like tiptoeing here through the tulips, all right? So he's like, blah, 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 jurisdiction. Let's move to the next. The next piece. Wow, that's a lot of discussion about that jurisdiction. All right. Here we go. I'll pick it up here because he starts to pull Congress back into the discussion. All right, finally, for those who find it relevant, the legislative history confirms Congress sought to eliminate the executive branch's ability to circumvent the Senate's advice and consent role through repeat or indefinite interim appointments. So this was all set up so that we didn't have this abuse of power out of the executive branch. All right, and then there's, spoilers, I guess, but they're going through again and discussing that. Here we go. We've hit B. So that was A. Now we're heading into B here. Ms. Halligan's appointment also violated the Appointments Clause. As discussed, the Appointments Clause allows Congress to, by law, vest the appointment of inferior officers in the president alone, in the course of law, or in the heads of departments. Through Section 546, Congress devised a statutory scheme that vests the appointment of interim U.S. attorneys first in, quote, the head of a department, end quote, and then in the, quote, the courts of law, end quote. Because Ms. Halligan was appointed in violation of that scheme, her appointment was not authorized by law, and thus also violates the Appointments Clause. Citing case law here, resisting this conclusion, the government briefly asserts that not every action in excess of statutory authority is ipso facto in violation of the Constitution. All right. Let's take. Do we all know what ipso facto means? No. This is where they're basically saying it had to. Let's walk back. Okay, resisting this conclusion, the government briefly asserts that not every action in excess of statutory authority is ipso facto in violation of Constitution. So that's just meaning like, because they're saying we've got a violation here, it doesn't necessarily mean it is indeed a violation. So the most frequently used phrase with an ipso is we call it res ipsa loquitur, which is a term we use in civil court, and it essentially translates into the thing speaks for itself. So here they're just saying you can't just say that it's okay and then put it and say that the Constitution's been violated. You can't just say that, even though they do that all the time. That is true, but beside the point. An officer cannot lawfully exercise the statutory power of her office at all, unless she's been properly appointed under Article 2. And we are citing Justice Thomas, all right? And here, Ms. Halligan has not been appointed, one, by the president, like abracadabra. Yes, just like that. All right, one, by the president with the advice and consent of the Senate, or two, through a process Congress has authorized by statute. Here they're quoting Thomas's dissent. You want to pull Thomas in as much as possible. Pull him in as much as possible. Thomas and Alito, right? Or Scalito. So an Appointments Clause violation has occurred. The next question is what to do about the violation. C, dismissal of the indictment is appropriate. So here we go. This is where we're setting out the analysis of why a dismissal is the proper road. The Appointments Clause is more than a matter of etiquette or protocol. It is among the significant structural safeguards of the constitutional scheme. Citing case law, the clause not only serves as a bulwark against one branch aggrandizing its power at the expense of another, citing the Ryder case, but also preserves another aspect of the Constitution's structural integrity by preventing the diffusion of the appointment power. Citing Freytag, quote, given its importance within our Constitution structure, citing Cody here, quote, remedies with bite should be applied to appointments that run afoul of the clause's restriction. Citing Brooks, and that's the last one. That's the last case they're citing for that. Here, Mr. Comey contends Ms. Halligan's unlawful appointment renders all her purported official actions void ab initio. So just everything needs to be done from the beginning. So ab initio means from the first day that you accepted being the prosecutor here, everything after that, all of that needs to go because it's not appropriate. He therefore argues the case must be dismissed because Ms. Halligan was not lawfully exercising executive power when she appeared before the grand jury alone and obtained his indictment. And the judge says, I agree. So we have definitely, we've got the judge saying that was not appropriate. When an appointment violates the appointments clause from the jump, I guess, so you could say, or ab initio, whichever, your call from the jump, the actor has exercised power that she did not lawfully possess. From the jump, I'm not sure about that one. All right, string citations here. Ooh, Gorsuch is in there. We love it when they pull in the justices that are available. Because then in oral arguments, all you have to do is pull this out and just say it repeatedly. Be like, I know I said that, but blah, blah, blah. And Gorsuch especially is very sensitive about that. If you bring in something that he has said in another case that is opposing what he's saying right now, he kind of gets mad about it. I think it's worth it, but I'm also not the one in front of him. Yikes. All right. Moving. Okay, an officer must be properly appointed before he can legally act as an officer. In such a case, the proper remedy is invalidation of the ultra vires action taken by the actor. So we're all over the Latin today, everybody. We're all over it. So this ultra vires means outside of the scope of your job description. So many times that's been happening here where they're saying, well, I'm the president, I can do whatever I want. And then the court comes back and says, or everyone sues under ultra vires, and the court comes back and says, no, this is actually outside of your powers, outside of your job description. So that's what our ultra vires means here. It has been, Krista, it's been bonkers today. I'm not sure when it was written, Joe, but it was filed today. I just printed it out. It just came out. All right, so taken by the actor. And then they're citing, which case is that? Then they're citing the U.S. v. Trump case. They're citing the espionage case. That's nice. All right, so that's a quote from his espionage case out of Florida. That's right, only the freshest. Good question, but it's going to take some time. It's going to take some time, as we all know, to get them. But eventually get them, we will. All right, invalidation follows directly from the government actor's lack of authority to take the challenged action in the first place. That is, winning the merits of the constitutional challenge is enough. In light of these principles, I conclude that all actions flowing from Ms. Halligan's defective appointment, including securing and signing Mr. Comey's indictment, constitute unlawful exercises of executive power and must be set aside. There is simply no alternative course to cure the unconstitutional problem. Again, citing that espionage case out of Florida. I'm loving that. We're citing Judge Cannon here. I'm enjoying that. Cancel TPS. Well, TPS is in a weird gray area, and it's one of those where I think a lot of our presidents did weird stuff for it. And, I don't know exactly how it's going to turn out. What I do know is that a whole bunch of people rely on those promises and are being harmed. So with that, I would say I'm not a big fan if you're not going to follow through. All right, the government attempts to counter this result with several arguments, but none is persuasive. First, the government argues that whatever her status as U.S. attorney, Ms. Halligan still validly obtained and signed Mr. Comey's indictment as a, quote, an attorney for the government. Here's our rule here. Federal Rule of Criminal Procedure, defining an attorney for the government as the attorney general or an authorized assistant. A United States attorney or an authorized assistant or any other attorney authorized by law to conduct proceedings under these rules as a prosecutor. All right. And quote, the following persons may be present while the grand jury is in session, attorneys for the government. So that's, again, the government's argument. Next, the indictment must be signed by an attorney for the government. In support of this argument, the government relies on the Attorney General's October 31st order, which purported to retroactively appoint Ms. Halligan to the, quote, additional position of special attorney, end quote, effective September 22nd of 2025, 3 days before Mr. Comey was indicted. here, although the Attorney General has the power to appoint subordinate officers to assist her in the discharge of her duties, that's U.S. v. Nixon, the government, because Nixon had a lot of problems, the government has identified no authority allowing the Attorney General to reach back in time and rewrite the terms of a past appointment. It's fair. It's fair. So everybody, I've got to hook up my next battery, so apologies. Here we go. Are we cooking? Am I allowed to say cooking? There's certain words I'm not allowed to say in my house. Like bussin'. That's been removed. I no longer have the ability to say bussin'. All right, here we go. Nor can the variation between September 22nd and October 31st orders be dismissed as mere paperwork error, as suggested by the government. That was one of my favorites. Like, oh, it was a clerical error. Like, what? I don't know about that. The September 22nd order was unambiguous. The Attorney General stated she was appointing Ms. Halligan under 28 U.S. Code Section 546 to, quote, serve as the U.S. Attorney for the Eastern District of Virginia for the period of 120 days or until replaced in accordance with the law, whichever occurs first. The October 31st order then purported to appoint Ms. Halligan to an entirely different position, special attorney, under entirely different statutes. Here, I reject the Attorney General's attempt to retroactively confer special attorney status on Miss Halligan, and rightfully so. Oh my gosh, the potato. I'm sorry, I love the potato. I can't get enough of the potato. Like, French potatoes are funny to me. Oh my gosh, regardless, I gotta stay on target. Regardless of what the Attorney General intended or could have done, the fact remains that Ms. Halligan was not an attorney authorized by law to conduct grand jury proceedings when she secured Mr. Comey's indictment. And then that's set out by the federal rules. I'm wondering too, though, there's a lot of steps that occur in order to pull in jury panel, right? So the notices have to go out to the peoples. The assignments need to go out. Usually we'll be like, well, who's going this week? Who's not going this week? Or for grand juries, which decide probable cause, there's like a list. There's like, here's our list of 20. Let's set them up, knock them down, and see what happens. But there's other people involved in the process. And I keep thinking, like, why didn't anybody tell her? Like, or why didn't she figure it out herself? Or did they think they were just too smart and that they'd make it past us? So that's one of my biggest questions. I'm like, she's just out there, like, lollygagging around, pulling in a grand jury, presenting evidence with a witness. Like, how's she just doing that? She doesn't know how to do that. Why did it get this far? Exactly. That's what I'm thinking. On the other hand, a lot of these people are just untouchable. Like, you don't want to touch them because if you cross paths with any of them, you might get the attention of the orange, and nobody wants that. We all need to stay behind the scenes. All right. Here's our footnote number 18, just to make sure we've get all sides here. That footnote was added here after indictment. The government attempts to frame the effect of Ms. Halligan's invalid appointment as nothing more than a violation of Rule 7's signature requirement. The government is correct that courts have treated the improper signing of an indictment, citing Wheatley here, as a technical deficiency that does not always require dismissal, citing Rory. Oh, I've seen that case out and about. That's interesting. Pulling that one back in again. Federal practice procedure, observing that courts have not rigorously enforced Rule 7's signature requirement. The problem here, though, is not that just Ms. Halligan's signature on the indictment. She presented the indictment to the grand jury alone without being a proper representative of the government. And you can't do that. That's not allowed. That's not allowed. Yeah, the thing with the grand jury, though, if you get called in, if you do if you're one of the jurors, is again, you're just hearing one side of the story, so you don't get kind of like that pomp and circumstance that goes with a full trial. But yet, on the other hand, you don't have to deal with all that pomp and circumstance. It can go quick. You won't get stuck in a motel for 2 months. If they're like, well, is there probable cause? You're like, I don't know. I'm going to have to think about it for like 6 weeks. No, we're having lunch in an hour. That's how much time you have. Second, the government contends that even if Miss Halligan lacked the authority to obtain and sign indictments when she appeared before the grand jury, her action should be entitled to de facto validity. Again, I think this is our fourth Latin term. De facto means actual versus de jure, which is like, what we would want it to be. So if you say, well, that's de jure, it's like, yeah, we would like to have a cure for a hunger, but de facto, like Congress doesn't want to feed children, hypothetically. So there you go, de facto, so an actual validity. And we're quoting Buckley v. Vallejo. Ooh, this is interesting. Buckley out of 1976. Okay. When applicable, the de facto officer doctrine confers validity upon acts performed by a person acting under color of the official title, even though it is later discovered that the legality of the person's appointment or election to office is deficient, citing Ryder. In other words, the doctrine operates so that a defect is an official's appointment in an official's appointment is not an adequate grounds to challenge his earlier decisions. So that's kind of like, that's a triage move, right? Because if you say, in this one situation you screwed up, so everything you've ever done in your entire career is suspect, that's going to be pretty bad. That's going to be next to impossible to hash out all the details on that. All right, so we follow here Vallejo, and that's just what we're doing. But the de facto officer doctrine applies only to some non-constitutional appointment challenges here. Applying the doctrine where an out-of-district judge assigned to replace a resident judge who had fallen ill continued to hold court after the resident judge is unalive. And then this one, holding that a properly appointed judge assigned to another district was a judge de facto, and that his actions as such, so far as they affected third persons, were not open to question, notwithstanding any question as to the validity of his designation. It has no application when the appointments clause challenges are involved. All right, is everyone following me here on what I'm saying? All right, so the government is saying she still had the authority. She just didn't have the signature. And the judge is saying, we need more than a signature, actually. All right, and however much more she had, it wasn't enough. So that's that. Major oversight, I know, right? I mean, come on, are you kidding me? Anytime, well, this is just my personal experience. Anytime I was going in for a jury trial, anytime we were working with jurors, whether it's the voir dire process or questionnaires or even delivering opening statements, you got to make sure you're bonding with the jury in an appropriate way. But this situation and how she handled the grand jury is just so offensive. It's outside of the scope of what we are all taught. So, I mean, it really is borderline offensive. All right. So dismissal will be without prejudice. Now I want to hear what his rationale is for that, right? Because you can file it, and I don't know somehow if the statute's been told in a way that will allow for it. So let's see. Yes, Ice Horse. I know, right? We've been on the struggle bus, but that's all right. Dismissal will be without prejudice, having found that Ms. Halligan's appointment violated 28 U.S. Code Section 546 and the Appointments Clause, and that dismissal of Mr. Comey's indictment is warranted. The remaining issue is whether dismissal should be with or without prejudice. Relying primarily on the Ninth Circuit's decision in the Bundy case, Mr. Comey urges me to exercise my supervisory powers and dismiss his indictment with prejudice, right? So they can't bring it again. A with prejudice dismissal is necessary, he argues, to vindicate the interest protected by the Appointments Clause and to deter the government from using unlawful appointments to effectuate retaliation against perceived political opponents. And that's another big piece, is how so much of this is just for like getting someone back because they said something here. So recognizing that a court may use its supervisory powers to implement a remedy for violation of recognized rights out of our case law here, and as a remedy designed to deter illegal conduct. The government, on the other hand, asserts that any dismissal should be without prejudice, for Mr. Comey comes nowhere close to showing flagrant misbehavior, substantial prejudice, or the unavailability of a lesser sanction, as required by the Bundy case, quote, holding that a district court may dismiss an indictment with prejudice for prosecutorial misconduct using its supervisory powers, only if there's a flagrant misbehavior, substantial prejudice, and no lesser remedial action available. So, and I can see that. I can see why the judge is like, well, whatever, whatever. Get yourself sorted out. Try it again, even though the statutes is going to be like, what? All right, here we go. Bring it home, everybody. Ultimately, I believe the Supreme Court's Appointments Clause jurisprudence provides the answer to the with or without prejudice question. In both Ryder and Lucia, the court essentially unwound the actions taken by the unconstitutionally appointed officer and restored the affected party to the position the party occupied before being subjected to those invalid acts. We've got Ryder here ordering a new hearing before a properly appointed panel, and Lucia, quote, the appropriate remedy for an adjudication tainted with an appointments violation is a new hearing before properly appointed official. So that's the second case here. And then also, oh my gosh, I'm going to say it wrong. Union, I probably said it wrong, I apologize. Vacating decisions made by an appeals panel that included a judge who was ineligible to sit by designation on an Article III court, and remanding for fresh consideration of petitioners' appeals by a properly constituted panel. This is questionable. I'm going to have to look this up. What do you mean he was ineligible? The judge was ineligible to sit on the court. Does that mean he was a state judge? And if so, what's he doing hanging around in the Article III courts area? Right? So that's a little hinky as well. Thank you, Big Grandma. I forgot. Okay. Anyway, I think that's kind of weird, but to each their own. Fresh view. I will invalidate the ultra vires acts performed by Ms. Halligan and dismiss the indictment without prejudice, returning Mr. Comey to the status he occupied before being indicted. Although you can never truly go back, right? So this one, as well as A.G. James, have both been dismissed without prejudice. All right, here's our conclusion. For the reasons set forth, it's hereby ordered and adjudged as followed. Number one, the appointment of Ms. Halligan as interim U.S. attorney violated 28 U.S. Code Section 546 and the Appointments Clause of the U.S. Constitution. 2, all actions flowing from Ms. Halligan's defective appointment, including securing and signing Mr. Comey's indictment, were unlawful exercises of executive power and are hereby set aside. Number 3, the Attorney General's attempt to ratify Ms. Halligan's actions were ineffective and are hereby set aside. So he's acknowledging, yeah, the AG came in to try to bail you out, but you're not going to get bailed out that way. All right, number 4, Mr. Comey's motion to dismiss the indictment is granted in accordance with this order. 5, the indictment is dismissed without prejudice. And 6, the power to appoint an interim U.S. attorney for the Eastern District of Virginia, pursuant to 28 U.S. Code Section 546, during the current vacancy lies with the district court until a U.S. attorney is nominated by the president and confirmed by the Senate under 28 U.S. Code Section 541. So it's a twofer. We've got the dismissal without prejudice, good luck with that. And then the next piece is the district court has jurisdiction over picking anyone else until the president actually picks one and it gets approved through the Senate, is what they're saying here. So I think this was a pretty well written. You probably can't hear me with all the shuffling here. I'm sorry. Here we go. Oh, here we are. I think this was pretty well written, honestly. I think he hit each of the points that were important. I think he laid I'm going to keep saying he, but I don't know actually if it is a he or what exactly identifications here. But I thought it was a he. Is this a he? I'm just going to... time's dwindling. All right, well... Judge is a woman. Okay, thanks, VC. That's what I was worried about. I can't just keep saying he if it's not a he, because that would be rude. Here we go. Cameron McGowan Curry. All right, Miss McGowan Curry, I apologize. So this judge wrote an incredibly well-written dismissal, taking care to not only address the issue of whether or not the case needs to be tossed, but also that the district court's the one in charge of the next interim attorneys. So this is actually pretty important because this could be used in other jurisdictions. Also, to remind everybody, the district court is the one that needs to choose who's going to be in that interim position until the president decides to hand somebody over to the Senate. They is okay. Okay. Yes, a great work. Oh, thank you so much. Oh, that's so nice, Joe. I appreciate that. You're the cutest lawyer. Oh, you're so sweet. I am. No, I'm not. I don't know. I've got some competition on this app for sure. There are a lot of really great attorneys out here. You're welcome. So does anyone have any questions? I'm looking at the time here. I may need to, I'll probably do Miss James's then in a different live, like later, or tonight or tomorrow. But I don't think I've got enough time to make it all the way through that one today. I love your lives. Oh, I'm so glad, Cherry. I'm so glad. And feel free to DM me if you are like, hey, do you mind? Could you talk a little bit more about res ipsa loquitur? Because, that's my jam. Was it dismissed with prejudice? No prejudice. But we do have to remember the statute of limitations on this case. Barely made it to the filing in time. They were dismissed, yes. Go to the appeals courts. So the government in criminal cases has almost no appellate power. Right? So if the government loses something in a criminal case, they can't just appeal it unless they believe there is some law interpreted incorrectly. And then it's possible. But you still take the loss. And I think that was shown again in the espionage case in Florida, right? So Judge Cannon had been like, you're off the case, Jack. And he's like, that's not how you read that statute. But the appeal kept going. The appeal off of what she was saying, as well as some other things, it still kept going forward. So, oh, it does. Okay. Oh, fun. Oh my goodness, everybody. Second episode of podcast comes tomorrow. Oh my gosh, I had so much fun. With him, with Mike. Oh my gosh, it was a great time. Sue for attorney's fees. It's possible. You got to kind of pick the hard road that you want to go down. Thanks, Felix. I would say if they try to do that, who's going to pay for it, right? At this moment, at this time, because he's being sued in his, quote, official capacity, any kind of sanctions or whatever would need to be paid by the government. That's another thing to think about as well. Yes. Oh, Carol, it's a great one. It's a great one. Looking forward to, yes, the James opinion. Yep. And again, these both came down today. So I would like to do, I have a queue of cases I want to do, but I don't want to leave this one hanging. So I will do my next live on Miss James's case. But if that's tonight or tomorrow, that I just don't know. Can they just refile if it's past the statute of limitations? So that's kind of an interesting question too, because if the government calls in a grand jury to do another indictment, but the indictment that they're working on has already passed the statute of limitations, I'm not sure exactly what the protocol for that is. Because this woman just walked into a room with a whole bunch of people and said, okay, well, you're grand jurors, here's some stuff, right? So that's already been screwed up. So in my understanding, that would never be a problem. But with this administration, yeah, I mean, it could be a problem. Why do you think the judge didn't dismiss with prejudice? She was going through an analysis of what really constitutes with prejudice, and you have to have almost this malicious element to it, and that's how our cases tend to go when we're looking at with prejudice. For example, the homicide case against Alec Baldwin, right? Does anyone remember that? The prosecutor there had been like in and out, filing and not filing, and so on and so on. So and then they screwed up, and the judge was like, this is gonna get dismissed. You screwed the case up here to the other side. And she said, and the other punishment, the only other thing I can do to try to take Baldwin back to where he was before all of this craziness happens would be to dismiss this with prejudice. So that's an example of when with prejudice would really kick in. If there's this negative, malicious kind of intent behind it, is an easy way to remember that. Oh, the flashbacks, yes. It does. It does feel like a malicious intent because we're walking a line. We're walking a very fine line here with this what's your name again? Miss Halligan. We're walking a fine line because between maliciousness and incompetence. So if your malice line isn't clear enough and it could be turned on incompetence, that's going to be a tough one to win. So I think we got to kind of take that into consideration as well. When the lawyer gave the grand jury and the judge two different ducks, well, she just may not have known. The argument from them is going to be she didn't know, first of all, which is probably the most truthful, or second, she didn't have to. Because if you've noticed, a lot of times the people out of his administration, they'll get called out on something and they're like, nope, that's not how it is anymore. And they just like cut it at that. So that's, yeah. So we have no definitive answers here because the administration's a little bit different, right? So you gotta be careful. Yes, this is official, Lisa. Yep, official. We have both Comey and James dismissed without prejudice here. And I will go through Miss Jane's rationale. They're going to have a different rationale for her not prejudice, right? Malicious incompetence, perhaps. But when you're dealing with incompetence, that's when you start going down the road of the ethics rules as opposed to a criminal act. Like I can't think of a criminal act that would cover what they're doing. Honestly, tons of ethical issues, but criminal act, I'm not sure. Will be appealed. Not sure at this point. Not sure because the government does not have the same appellate power as the defendant does, right? So if they lose, right, so we don't have double jeopardy is the big piece. Because this did not have any finish other than dismissal, it's possible that it might be able to be brought back, but the statute of limitations has run. So I just don't like to say it's not possible because with this jurisdiction or with this administration, seriously, they could very well pull up an old piece of something from 1750 and be like, well, here we are, we're refiling it. So that could be it. So when it comes to whether or not it can be appealed, that's a delicate question. Yeah, it's not over yet. That's right. That's right. They could come in and appeal and say that the dismissal was unwarranted under the law, right? Which would be the same as what happened in the espionage case, right? That's what Jack Smith was appealing. He was appealing the ending of that case because she had interpreted the law incorrectly. So if you get into that kind of a question, it's possible. Still apply. Yeah, I think so too, Vonda. I think it would. They have to find someone willing to file again. Oh my gosh, Tammy, that's the problem. That's the problem. Rather than saying, oh my gosh, all of these attorneys are quitting their jobs, which are tough jobs to get. You get a lot of power and prestige with those jobs. And more importantly, they're going to lose their health insurance. And who can afford that anymore? Goodness gracious. So they're doing that because it's so serious to them. It's so unethical. They're willing to give up a lot of the benefits in the career because they cannot follow that order that's unconstitutional. So bummer for them, but also thank you. You are fighting attorneys out there walking away from unethical filings. And then, of course, all that leads to then are the attorneys that are there, which have no problem, disregarding ethics. So that's a bit, disconcerting. a little bit. Can you hire a different attorney? Good question. And no. These are, for these two cases, these are criminal cases brought against two people brought by the government. So the federal government is bringing the case. That's all DOJ. That's got nothing to do with the president. That's all DOJ business. So because of that, they could probably move attorneys around maybe in the DOJ and find a different one. But the DOJ is like a ghost town. Like in the Old West where you see the tumbleweeds going through the halls, that's the DOJ right now. That's it. Everyone's like hiding in the saloon. That's the DOJ that we have right now because there's nothing left. They have pretty much burned it all. So now they've just got a few people, walking around in there. So might want to tell him that, well, that's above my pay grade. That's not what I can do. All right. For the attorneys that stayed, could their legal team receive any consequences? You mean, hi, Ethan. Hi, welcome. You mean after, right. So these, the rotten ones, will the rotten, I can't say that. The attorneys that stayed, right? Could the legal team receive any consequences? I don't think so. As long as they're acting in good faith. You cannot use the phrase, I was following orders. That doesn't work here. We just don't do that here. But if you can say you're incompetent, so that takes out that malicious piece to it. But again, who's going to hold them accountable is the ultimate question. And we are being asked that constantly now, right? Because the DOJ apparently opened up an investigation into this administration. Did anybody see that? It's like, what? The DOJ is investigating itself? I'm sure it will be non-biased and fair by all means. But so it's a little bit weird. No consequences for filing unless it's seen as malicious. I would say for the teams working, Vonda. For Miss Halligan, she's already getting dinged in the ethics area. So she's already had a complaint filed against her, actually multiple complaints. So there's the ethics road to go down where she's already going to need to start taking care of that business. Perhaps if Florida gets its act together. And then the other road, right, which would be criminal. And I don't see any criminal actions here. I don't see anything that would rise to the level of a crime. We've got malicious prosecution, up in the air that everyone's talking about. True, but that's a very specific area. So it's not one that you're going to just see all the time. I'm wondering though, when we get into Miss James's case, quite frankly, I think we're going to be dealing actually with some malicious prosecution. Let me just look real quick here, because her case is like nothing if not an abuse of discretion. So let's just look here quick. 2-count indictment. We used to dismiss on the ground that the sole prosecutor was unlawfully appointed, right? Constitution explained attempt to install, right? Okay, so I guess not. I guess it wasn't put in here. They didn't need it. I mean, all they needed was one good hook, and they had that with the appointments clause. So there's that. That was a long answer to a short question. Hello, a more perfect podcast. Word on the street is tomorrow there might be another fun time coming down, right? Why was Trump mad at James Comey? It's a good question, and I guess I would answer it by saying there's no way to know why the orange gets mad, truly, because it seems like he gets mad about some stuff, but not other stuff. So, yes. Oh, part 2 comes out tomorrow. All right, everybody, don't forget, part 2 of A More Perfect Podcast comes out tomorrow. Yes, thank you, Kaya. Thank you so much. Oh my gosh, seriously, we're talking about the Declaration of Independence. I mean, how is that not fun, right? I mean, it's just fun. It's just pure fun. It's laughs, and also, you can think about your future. That's part that's part of the fun, right? Oh my gosh. All right, with that, my friends, I probably need to get headed out. So I do have Miss James's case will be my next live. We'll see how I'm feeling tonight. I'm not sure that I will be up to reading through this one, but the next live I will be doing hers. So make sure you've got your notifications turned on. This kind of like lunch hour right now that I'm working with, or kind of later lunch, seems to be working really good with my stuff right now. So it may be another lunch and learn tomorrow. You are most welcome, everybody. Most welcome. I will, Vonda. I know my voice hasn't recovered from the laryngitis and the bronchitis. It's not quite recovered yet, so still working on it. Have a great rest of your day, everybody. I will see you all very soon. Thank you for all of the gifts. I'm so grateful. That little potato just made my whole day happy. Happy French potato. So have a good one. I'll see you all again very soon.